Welcome to this discussion on IPR, intellectual property rights. With me I have Basse Asplund from Brann. So I'm going to start straight away. We've heard recently on the news that Sweden is the second largest filer of patents in the world, which sounds pretty impressive. But why do you think that is, and also what is a patent?
First of all, it is impressive. And I think it originates from that we have had for many, many years successful tech companies, famous entrepreneurs and inventors that we are very proud of. And the status of engineering knowledge is very high in Sweden. We tend to value that type of knowledge very much. And your questions regarding what a patent is. A patent is a contract between an inventor and the society where the inventor gets an exclusive right to stop others from using your invention during a limited period of time. In return, you have to disclose your invention. You have to make it available to the public.
Great. Thank you for the clarification. It's important to know. And you're mentioning successful inventors, successful entrepreneurs. How much in that success would you say is IPR?
Well, quite a lot, actually. I mean, I believe that IPR has and still plays a very important role in those companies, simply because experimental data, technical solutions, process setups, trademarks and so on are very important in order for those companies to be successful. And this is not only true for large corporations. Even small companies know today that their success is partly dependent on IPR.
Can you elaborate just a bit more on what you mean by saying that?
Well, small companies patents for small companies, for example, is a key for them to find, sometimes at least, to find fundings and to initiate collaboration agreements with other companies.
So it does sound good, but I'm not in the field. Could you just explain a little bit more for us that are not in the field?
Well, a way of focusing on business with patents is that, for example, a patent applicant usually wants to obtain the broadest possible protection for their invention, which is fair. I understand that. However, that might result in very high costs and a lot of time it takes to persuade an examiner. Instead, if I still ask my client that, how would it affect your business if we limit the scope of protection? And quite often the answer is, it doesn't affect our business because we're still encompassing our product, and the parts that we're not covering anymore is not interesting to our competitors for some reason. It's too expensive, it doesn't work, and so on. So from a business point of view, we still protect our business with this patent that we might obtain much faster if we limit the scope of protection.
Okay, that sounds like an interesting strategy, but how would you say that this process actually benefits the startup of the company?
Well, by placing the business in center of attention when discussing IPR, not only discussing but also making the decisions, those decisions will be more in line with the business plan. And for example, if you do a yearly review of your IPR portfolio, you will end up seeing that you have patents or trademarks that you don't even use anymore, that you can drop and save money. And at the same time, you might see that, okay, we might have to register new trademarks or apply for new patent applications.
Interesting. So now we've talked about the company, their IPR, and how they should look and work with it. What would you say about competitors' IPRs and looking at the market, and how should companies think in regard to that?
Good question, because it is important to realize that patent is a negative right, which means that it only tells you what others are not allowed to do. It actually doesn't say what you are allowed to do.
Okay, I think you will have to clarify that. So I get a patent, but I'm still not allowed to do something with it?
Well, you may be allowed to do it, but the thing is that your product might be dependent on somebody else's patent, actually.
Okay, so you can still obtain the patent, but it borders with an already existing patent.
Exactly, and that's why we sometimes talk about freedom to operate,
Okay.
where we discover, for example, problematic patents from others. Yes.
So you scout the market and you might find a problematic patent. What do you do if you do find another patent?
Well, you might find an old patent that might expire quite soon. So you may, for example, wait until it expires. Or you can try to circumvent the patent, see if there's a way of designing around it. Or a third option could actually be to contact the patentee and see if they're willing to give out a license. There are options of removing problematic patents. There could something called opposition and invalidation processes. Yeah.
So it sounds like there are several different options, but considering limited resources, how would you say that a startup or company has to go with it?
Well, for example, if you discover a problematic patent application, that is, an application is not a granted patent, you may actually monitor the prosecution of that application, which means that you might see that, okay, with time, the scope of protection is limited and thereby you fall outside their scope of protection. And you can actually file your own arguments against that patent application. And hopefully you might affect the outcome of it.
It sounds quite complex and maybe even lengthy and pricey. And I mean, if the company doesn't have that expert competence, how can they go on with doing that and prepare for it?
Yeah, of course, it is a very complex world, IPR, the world of IPR, and you should work with experts. And you should make sure that the experts are committed to you and your company. So, because only then you can obtain the best advice for you and your business.
That's great, thank you. Before we end this chat, is there anything else you would like to add that is important?
Well, I would like to stress that it's important not to make IPR sort of an isolated part within your company, but a very central part of your business.
That's great last words. Thank you, Basse, for taking your time and sharing your knowledge with us. And thank you, Brann, for supporting entrepreneurs.
Thank you.
Before we end this talk, I have 3 key takeaways that I want to share with you. The first key takeaway is base your IPR on your business plan. IPR is a valuable asset. And the third key takeaway is patents don't give freedom to operate. So don't forget that. Thank you.